Welcome to a podcast presented by Knockamson PC. In this podcast, David Kohler explains the estate planning tool of a living will and why a living will should be a part of every person's estate plan.
To accept, reject, or discontinue medical care and treatment. If you have not been deemed incompetent to make medical decisions by a doctor, or if you have not been determined incapacitated by a court, then you may direct, by a living will, your medical treatment. A living will is a written document that you may use under certain circumstances to tell others what care you would like to receive or not receive, should you become unable to express your wishes at some time in the future. In Pennsylvania, a living will is known, according to the law, as an advance directive for health care. It essentially describes the kind of life-sustaining treatment you want or do not want if you are later unable to express your wishes to your doctor. Any competent person who is at least 18 years old or is a high school graduate or who is married can make a living will. There is no single way to write a living will or declaration. However, your living will is not valid unless you sign it. If you are unable to sign it, you must have someone else sign it for you, and two people who are at least 18 years old must sign your living will as witnesses. Neither of those witnesses may be the person who signed your living will on your behalf if you were unable to sign it yourself. You should give a copy of your living will to your family doctor and to an immediate family member, a close friend, and to your lawyer. When you enter a hospital or nursing facility, the law requires your doctor or other medical care provider to ask if you have a living will. If you give a copy of your living will to your doctor or other medical care provider, that written document must be made a part of your medical record. Your living will become effective when your doctor has a copy of it and when your doctor has concluded that you are incompetent and either in a terminal condition or in a state of permanent unconsciousness. For terminal conditions or permanent unconsciousness, a second physician must confirm your doctor's conclusion. Your living will may be revoked by you at any time and in any manner.
Thank you for listening to our podcast. Knockamson PC is a law firm representing individuals, businesses, and professionals throughout Pennsylvania and New Jersey. For more information about Knockamson PC, please visit our website at www.knockamson.com or call 215-399-1346 to schedule an appointment to meet with one of our attorneys. This podcast is a publication of Knockamson PC and is intended for general information only. It should not be construed as legal advice with respect to any particular situation, and listeners should not act upon information contained in this podcast without first consulting an attorney.